Thank you. Thank you so much, Flashiti. Excellencies, Mr. and Madam Prosecutor, professors, dear colleagues and friends, I'm so happy to see you here in person for those who have been able to join us in The Hague. And I know that there are many more people following online, so really welcome to you all for this launch event for Global Rights Compliance Practitioners Handbook on extraterritorial and universal jurisdiction to pursue accountability for international crimes committed in Ukraine. I promised that we tried to come up with a shorter title, but we thought we would stick with one that clearly describes what we aim to do with this handbook, and this is what we'll talk about in further detail and together for the rest of the evening. We are delighted to see you all here, and I would like to first thank the Ather Institute for welcoming us today and making this event possible. I would like to thank our panelists for being here. I will introduce them in further detail and we'll have the pleasure of hearing from them. Bejan Sulzer from Global Rights Compliance, Mateusz Perditz from the Genocide Network at Eurojust, and Alexander Zeus from the Ukraine Office of the Prosecutor General. But first and foremost, I would like to express a very warm thank you and welcome to His Excellency Mr. Andrew Kostin, Ambassador Extraordinary and Plenipotentiary of Ukraine to the Kingdom of the Netherlands, former Prosecutor General of Ukraine. We are delighted to welcome you here today and to give you the floor for some opening remarks. Thank you.
Thank you. Excellencies, dear ladies and gentlemen, dear colleagues and friends, our partners in delivering justice to victims and survivors of this illegal war of aggression. It's a great honor to address you today in The Hague once again in the Ather Institute, and thank you for inviting me and thank you for handling these very important events. As victims and survivors, as all of us legal professionals should point out, should remind politicians, should remind ourselves, should remind those who suffer from this war that our fight for justice is going on and it will last until every perpetrator will be held accountable. Maybe someone of you will think that this is impossible. Maybe we will not find out each and every of them. But it's our aim to use all resources we have, all institutions in place, all instruments in our hands, and if even they don't exist at the moment, to propose new ones, in order to ensure that there will be no safe haven for those who intentionally ordered commission of international crimes, committed international crimes on Ukrainian soil against people of Ukraine, and not only actually people of Ukraine, against many others from the other nations who suffered from this illegal conduct. Today's launch of the guide on extraterritorial and universal jurisdiction to pursue accountability for international crimes in Ukraine is not only timely, it's necessary. Ukraine welcomes and fully supports efforts to advance practical tools for accountability. And within the first days, we started our work on investigation, on documenting investigation and prosecution of war crimes, international crimes at large. We always thought about the loopholes the system has, about some mechanisms and some instruments which were not used properly or fully before that. And taking in mind that one of our obligations, one of our common roles or joint efforts is to propose new upgrades or updates or new instruments that can fix and develop existing instruments in order, once again, to ensure that there will be no safe haven. This guide is a testament to the growing global commitment to ensuring that perpetrators of international crimes will be held to account, regardless of where they are found. Since February 2022, Ukrainian investigators, prosecutors, and judges have been tirelessly documenting, investigating, prosecuting, and deciding on cases related to war crimes, crimes against humanity, and other international crimes. The recent figures speak for themselves. Ukrainian law enforcement agencies launched an investigation into more than 166,000 incidents of war crimes, as well as crime of aggression and crime of genocide. The scale of atrocities is unprecedented, and Ukraine needed to rely on assistance and help of our partners. And we are grateful that our calls for help were heard. We are thankful for all of the assistance of our partners we received and receive daily. It is crucial. We aimed not to confine justice to these crimes within national borders. And this is where we need to talk once again about our doctrine of comprehensive accountability, which we name the web of accountability. It's quite interesting that one of the operations of our military was also used the word web in it. So it was not intentionally, but you know, it's something about interesting coincidence. Coming back to web of accountability, these complex accountability metrics consist of 5 essential elements. The first element I have just mentioned, it's Ukraine national investigation and prosecution efforts. The next element, which Ukraine is actively stimulating, is bilateral and international investigation efforts based on extraterritorial and universal jurisdiction. Here I would like to underscore the role of all those institutions who were in front of coordinating these efforts. First of all, Eurojust, Europol, European Commission, because inventing joint investigation team in the March of 2022, creating CSET at Eurojust, Core International Crimes Evidence Database, a unique instrument where the government, where the law enforcement authorities can share information about the evidence, and the others can apply for this information to receive it and to have complete case, because there are cases where you need 1-2 elements to complete it, to have enough to charge someone. And once we will not find where to get this last element, then this case will wait maybe forever until we will find enough evidence. That's why these unique instruments which were created are critically important to go ahead and to have more cases. Once again, either investigated and prosecuted in Ukraine or with the help of joint investigation team. And actually, maybe some of you know, our JIT under the Eurojust, where we have 7 participants, not including plus ICC and plus Europol. It's not the only JIT. We have other JITs which were created on bilateral and trilateral basis, which are working and producing their results. That's why I think that JIT, which is investigating international crimes based on extraterritorial and universal jurisdiction, has already yielded results. We know charges brought by Lithuanian Office of Prosecutor General. We know actually the other case, which was the first charge brought by the third country about the crimes, international crimes committed in Ukraine in course of this war. It was brought by US Department of Justice at the end of 2023. And this is also quite a unique experience, how we handled this cooperation on bilateral and basis and on basis of joint investigation teams. So one of the aims of using of this second element of the web of accountability was not only burden sharing, but also to extend or expand geography of countries who are with us, not only helping us in capacity building, not only helping us to collect evidences, because, you know, millions of Ukrainian refugees reached law enforcement agencies in many countries and shared with the evidence they have. But it's also, once again, to show that there will be no safe haven, that perpetrators, once they appear in the other countries, will be brought to responsibility. It's also very important for the victims of these crimes, because every new verdict or confirmation of charges brought by not only Ukraine and the ICC, but other jurisdiction, is very important, because it also shows that we are backed as Ukraine, as the Ukrainian government, as Ukrainian law enforcement authorities. We are backed by our partners and we are supported. And if such countries will do more in order to go ahead with their criminal cases, I think it will give more hope and more trust from Ukrainian victims and survivors of these international crimes, trust for justice, trust that justice will be delivered, and what I always mention, will be delivered in time, sooner than later, while they still remember, while they are still alive. Third element of our web of accountability, of course, it's international justice institutions, and first and foremost, the ICC. And the ICC is also working with the instruments where the other countries are collecting evidences and can share. The ICC is also working with the Core International Crimes Evidence Database to try to get additional evidences they need. So it's not only the cooperation between Ukrainian and authorities and the Office of Prosecutor of the ICC. It's once again about all of the elements of the web of accountability which are interlinked and which are complementary to each other at the same time. It's quite maybe difficult to understand why, how it happened, but this was our aim, how to construct the system where all of the elements are complementary to each other on the one hand, and they contribute to each other efforts. This is, I think, the most practical result of the web of accountability we have introduced. Of course, the 6 arrest warrants already issued by the ICC is, I think, one of the best evidence of how Ukraine cooperated with international justice institutions. Of course, we also work with UN Commission of Inquiry. We also work with OEC institutions, and all of these elements, they are bricks in a big building which we built together. The fourth crucial element, of course, is a tribunal for the crime of aggression. I mentioned that Ukrainian authorities already we are investigating the crime of aggression, but we understand that from the point of view of needs of international community, it's critically important to put like 20 or 30 highest members of Russian political, military and law enforcement regime on the international level, and to try them on international level. And this progress we have now together, I think it's a great evidence that these efforts are also yielding good results. And of course, compensation mechanism, which is the fifth element, so the element of reparation and compensation for the victims and survivors of this war, is critically important. And once again, this is also interlinked, because the most important evidence which would be used is that people suffer from international crimes committed in course of this war of aggression. That's why all of these 5 elements are critically important to work together. I intentionally paid attention not only to just extraterritorial and universal jurisdiction efforts, because this very topic is linked with all others, and this very topic contribute to the others, and they contribute to extraterritorial and universal jurisdiction itself. That's why it's very important to work with them all together. So, I would like to thank the Global Rights Compliance, my very close friend, Wayne Jordash. Yes, and I wanted him to be here, and I hope to meet him as soon as possible, because he and his team, they delivered great results to our joint efforts, and whole team of Global Rights Compliance. So thank you for contributing to our current needs and for the future. The Esser Institute, once again, thank you for and all of the partners who were involved in the development of this guide. Ukraine is deeply grateful for your expertise, consistency and solidarity. I also would like to thank the Kingdom of Netherlands, our partners from Ministry of Foreign Affairs, our key partners for Ukraine in our pursuit of accountability. Your principal support, including on the essential accountability tracks, is crucial. My dream was always, I will remind it all the time, to have The Hague as the capital of international justice for Ukraine. And we are coming very close that all of the elements I already mentioned on international level will be settled in The Hague. This is important. Let us also bear in mind that the attack of Russia against Ukraine back in 2014 and subsequent full-scale Russian aggression has not only been a direct assault on our people, our sovereignty and our territorial integrity, it's also an attack on the very foundations of international law and justice. Therefore, let us continue to work together, not just to document crimes, but to prosecute them wherever it is possible. Not just to support Ukraine, but to defend the very principles of the international legal order. You know, each and every brick is important to build a house. Each and every effort is important to establish justice. Thank you, dear colleagues.
Thank you so much, Your Excellency, Mr. Ambassador, for this very insightful and powerful speech, which reminds us all why we are here and why we do what we do. I know that I speak for all of us at GRC and beyond when I say that we are forever impressed and grateful by the work that is carried out by Ukrainian prosecutors and investigators, both on the ground, of course, in Ukraine, but also in the Ukrainian embassies and on the global networks that you accomplished to create. The handbook that we have the pleasure of launching today is a result of about a year of work for GRC's Universal Jurisdiction team. And it comes to conclude the project, which started when we realized that although universal jurisdiction can be and is a key and crucial tool to achieve accountability for international crimes committed in Ukraine, there was no dedicated resource that was both tailored to the Ukrainian context and or available in Ukrainian. And so this is exactly this gap which we aim to fill by drafting, putting together, and now launching this handbook. First, and this was really dear to us, the handbook is available in both English and Ukrainian, and you can access it by using the QR codes that have been disseminated across the room for those at Asser Institute, and which I believe you can see on screen if you're following us online. Second, this handbook aims to serve as a tailored and practical tool for prosecutors, lawyers, investigators, civil society organizations, and other legal professionals who are engaged in seeking accountability for international crimes committed in Ukraine since the first Russian attack in 2014, and even more tragically and crucially since the full-scale invasion in February 2022. More specifically, this guide aims to help professionals and practitioners navigate universal jurisdiction laws to efficiently and effectively bring cases for international crimes committed in Ukraine out of Ukraine and push them before other domestic courts that have jurisdiction over those crimes under either extraterritorial or universal jurisdiction principles. To this end, the handbook is structured in 5 sections. The first section is an introduction which explains what we are here today to explain. So what is the background of the project, what is its purpose, its scope, its methodology. So in maybe more words and a bit more formally what we are discussing now. The second section of the handbook discusses the principles of extraterritorial and universal jurisdiction and how they could be used as a novel and complementary way to effectively investigate and prosecute crimes committed in Ukraine. And Jeanne Sulzer, who was the project lead, will explain in more details what we mean when we say that this handbook aims to really foster a complementary approach to universal jurisdiction, which is possibly the first, or at least more like wide scoped use of this novel way to use and approach universal jurisdiction. The third section of the handbook details the various ways of triggering extraterritorial and universal jurisdiction cases before the relevant forum, detailing the different procedural requirements that are common to most states that have introduced universal jurisdiction laws. For example, the presence of the accused person on the territory, sometimes dual criminality, and all these other legal concepts that are key to really understanding and then using universal jurisdiction laws, depending on which forum, which countries we want to operate under. Section 4, again, a more general section about universal jurisdiction, discusses a different procedural framework under which extraterritorial and universal jurisdiction cases may be opened, highlighting, for example, the difference between structural investigation, so investigations into a wider situation in which many crimes have been committed without necessarily having to pinpoint one case or one suspect, and investigation into specific crimes, specific suspects, which may be opened under different jurisdiction. Section 5, which is our last of these general sections, discusses the different international cooperation mechanisms that can be implemented, that have been created, that can be implemented between Ukraine and third states and international organizations to ensure better cooperation, better coordination, and an effective prosecution of international crimes, to make sure, as Ambassador Kostin pointed out, that there is no safe haven for perpetrators of international crime committed in Ukraine, but that regardless of where they may be or where they may travel in the future, they won't fall outside the umbrella of international justice. Those 5 sections that, again, are sections that are general to the context of Ukraine, of universal jurisdiction, and how universal jurisdiction can be used in this specific context, are made a bit more practical, more visible by using examples that are specific to Ukraine or relevant to the Ukrainian context, as we really wanted this guide to not just be another resource on universal jurisdiction generally, but to be the most practical and the most tailored as possible to be used in this specific situation of international crimes committed in Ukraine. Lastly, Section 6, with its both the longest and I believe the most unique feature of this handbook, details the relevant national laws of 13 countries on extraterritorial and universal jurisdiction. There are 13 countries, 13 states that we have selected either because they are members of the joint investigative teams for Ukraine, which we'll talk about a bit further, and are therefore states that are likely to possess evidence of international crimes committed in Ukraine, that have already engaged in international cooperation with Ukraine, and are really at the forefront of this united front of international justice and prosecution. So either because they are members of the JETS, either because they are neighboring countries of Ukraine or states that have welcomed an important population of Ukrainian refugees and have therefore been states that received complaints or that received statements of Ukrainian victims and witnesses of crime, and therefore again possess evidence that are relevant to the investigation of crimes committed in Ukraine, and that may provide relevant information to ensure that these cases move forward. Or lastly, and that the third category of states which we have included in this handbook, states that have adopted very progressive universal jurisdiction laws, that have a strong experience in handling universal jurisdiction cases, and or that have already created dedicated prosecutorial investigative teams to investigate those cases. And for this reason, states before which, although they might sometimes be further away from Ukraine, both geographically and culturally, I think, for example, Argentina, which is one of the states that we included. It's the only state that we included in Latin America, but is a state that has shown a great effort, energy in prosecuting international crimes committed abroad. They have adopted very progressive laws, and this is one reason, again, for which we included it in this handbook. So for those 13 states, that the list of which you have in the handbook, if you were able to access it, we have addressed different crimes that may be subjected to universal or extraterritorial jurisdiction in the laws of the state, the jurisdictional requirements that must be met to trigger a universal extraterritorial jurisdiction case before the domestic laws of this case, practical information on the applicable criminal procedure, including regarding victims' participation, which we believe was key to ensure that Ukrainian survivors can participate in procedures, even when those procedures are being taken forward, investigated, prosecuted before other forum in third countries. And we lastly included relevant examples of universal and extraterritorial jurisdiction cases that have been open and that have been moving forward before the state, including all of the cases that we could find a trace of that have been made public regarding the crimes committed in Ukraine. So all cases open in Lithuania, in the US, in France, in Germany, they're all mentioned in this handbook. And we also included sometimes examples of cases opened for crimes committed in other countries because they brought an interesting and relevant perspective to the work that we were trying to achieve with this handbook and are relevant to the prosecution of crimes committed in Ukraine. So again, to really make this handbook the most practical, the most tailored as possible, we have met with Ukrainian and foreign prosecutors and lawyers, judges, academics, members of CSOs. We've conducted two visits in Ukraine. Some other members of our team have traveled to The Hague, to Poland, to meet with practitioners, to ask them again about their experience, their practices, their perspectives, and the challenges that they have faced in their endeavors to investigate and prosecute crimes committed in Ukraine. And it's based on this conversation and the insight that we could get from them that we really structured and tailored this handbook. We have also sought the assistance of practitioners from the 13 countries, which are included in this handbook, who kindly accepted to review the relevant sections to ensure that they are really based and grounded in current applicable laws and procedures and court practice. So really on behalf of GRC, because I know that some are with us today, I want to really take the opportunity to thank all the person without which this handbook could not have been published today and couldn't have been drafted in the way that it is. So lastly, and before we move to our panel discussion, I just want to end by saying what this handbook is not. This handbook is not a call for foreign jurisdiction to take over or replace the Ukrainian judicial authorities in their mission to investigate and prosecute international crimes committed in Ukraine. Ukrainian prosecutors, investigators, lawyers, judges are doing a commendable and highly impressive job in tackling an ever-ending load of cases while fighting back the Russian invasion. And we at Global Rights Compliance have been first-hand witness of these efforts, the dedication and talent that are being put on display every day by Ukrainian prosecutors and investigators. However, what we have seen on the ground is also that Ukraine and Ukrainian prosecutors and investigators have shared with us that have a limited human and material resources, that they are simply and understandably overwhelmed by the sheer number of cases that have been opened since 2014 and even more since the beginning of the full-scale invasion in 2022. And as a result, cannot realistically investigate and prosecute all of those cases cases without the effective and timely assistance of third states, either because they possess the resources to do so, because potential prosecutors may be traveling to these states, or just because it is in their duty and mandate to step up when crimes are committed against Ukrainians and against humanity as a whole. So this is why we hope to do with this handbook. It is to serve the development of a complementary approach to universal jurisdiction, under which all states which have the judicial, legislative and material resources to do so step up and share the burden of Ukrainian investigators and prosecutors to work along them and ensure that international crimes committed in Ukraine are being investigated, that those responsible are being prosecuted, and that victims can see justice done. So with this, I think we can move to our panel discussion. Again, you have the handbook QR codes that allow you to access it. In exclusivity, it will be shared to the wider public tomorrow, but if you want to already go ahead and skim through it, spend your nights reading it, we will be most honored. So moving to our panel discussion, thank you again to you three for being here. Maybe I would like to start with you, Jeanne. So Jeanne Sulzer is a French lawyer. You have a long and really in-depth expertise of universal jurisdiction proceedings for having successfully brought several of them before French courts. And you were team lead of Global Rights Compliance Universal Jurisdiction team. So maybe could you please start by presenting the background of the project and to describe a bit more precisely and more eloquently than I will ever be able to do what we are talking about when we advocate for a complementary approach to universal jurisdiction for crimes committed in Ukraine.
Thank you, Clara. Thank you so much, Excellency. Again, I'd like to extend my thank. We are really honored to have you on for today's launch, to all of you and all the representatives of states and international organizations and colleagues from the academia and CSOs and lawyers. Big welcome. About the project itself, you've said much. You've said most of it, Clara. Maybe a few words about the structure itself of the project. First of all, a big thank you again for the support of the Dutch Ministry of Foreign Affairs, without whom we wouldn't be able to have that project done. But also to say that we implemented the project in partnership with IDLO, the International Development Law Organization, with the Esser Institute, which of course we thank for being here as well, and the Center for International Legal Cooperation, and the Netherlands Helsinki Committee. All of these logos you have here on the screen. So it's a collaborative work. We're all, I think, working towards the same goal, which is to work towards in the fight against impunity for crimes committed in Ukraine. The consultation that Clara was talking about, that we held both in Ukraine and also outside of Ukraine with practitioners, led to a couple of conclusions. One is the fact that there was a need for a practitioner's handbook or some kind of a handbook in Ukrainian, but also targeted to the needs of Ukraine with regards to international crimes. So that's the practitioner's handbook that you have in front of you. There are two other tools that we're working on. One which is forthcoming and will be on the website of GRC hopefully very soon, which is a visual mapping of all the universal jurisdiction and extraterritorial cases that have a link with Ukraine, which of course we will update, otherwise it's totally useless. And by the way, of course, in the handbook, there are a couple of cases that have been put as illustrations, but of course, as you know, justice is long, but sometimes it does move, so it will be obsolete at some point, whereas our mapping on the website will be updated. So that will be a visual mapping with an overview of the legal proceedings. Just maybe a word about what we mean by universal jurisdiction is relatively clear. In usually when we talk about UJ, we do include passive and active personality cases. So that means that in our handbook and also in the visual mapping, you will find both pure universal jurisdiction cases, which are not that common. To be honest, at least with regards to crimes committed in Ukraine before domestic courts of foreign states, but also passive personality cases where victims are nationals of that state, as well as active personality cases where alleged perpetrators are the nationals of these states, which are much more common and are basically the core of what we actually know today of what are the practice of domestic jurisdictions. The third tool or instrument that we have decided to work on as part of the conclusion of the consultation is to work with the Office of the Prosecutor General towards some sort of, whether it's a policy, a strategy, the implementation of the current policy that the OPG has, the 2023-2025 policy on international justice, with really an aim at looking at that question of positive complementarity approach. And this is a work that is ongoing with the OPG and hopefully will be public or out in a couple of weeks or months. So these are the three projects. Now, with regards to our approach and talking about a positive complementarity approach, of course, we all know, based in The Hague, and we're following what the ICC is doing, this is in reference to the ICC. When we talk about the positive complementarity approach, this is just a way of looking at it in a different complementarity perspective as the one that the ICC is governed, which is the complementarity between the domestic court and the ICC. With a positive complementarity approach, the idea is to implement what Ambassador Costin has been describing as a web of accountability with a proactive approach from the different institutions that have a role to play. In most cases, if not all, there are so many examples that I'm not able to actually turn to any of them. I have one in mind, but I'm not sure, maybe in the Q&A. Universal jurisdiction is used as a last resort, and is used as a last resort only when neither the domestic jurisdictions nor the ICC is able to step in. So we've seen a lot, unfortunately, of UJ stepping in with efforts from civil society and from victims to bring justice for crimes committed in Syria, for example. And that's clearly where UJ has been extremely helpful in Germany, in France, in the Netherlands, in many countries to try to fight against impunity and bring some sort of justice for the victims and put the perpetrators before a trial. It is quite unprecedented to have a country which proactively and its institutions proactively support the exercise of universal jurisdiction at the same time as it does support the exercise of the jurisdiction from the ICC, and of course its primary responsibility, which of course it is, of prosecuting and investigating before the domestic courts. That is to be understood in the context of unprecedented and growing caseload of international crimes to be investigated and prosecuted, given the scale of the armed aggression of the Russian Federation against Ukraine. And this is the growing caseload that unfortunately continues to happen. So there are significant challenges that persist, which will lead to using all this web of accountability, which also can be explained or useful with regards to sometimes the limitations that may exist at the national level, which may impede sometimes the investigation of the full scope of the crimes. Other reasons may be that of the relocation of a number of victims or survivors in third countries where they are unable or unavailable to contribute to domestic or to Ukrainian investigations in Ukraine, but they are able to support the establishment of the truth and access to justice for them before other courts. There's also the issue of unlikelihood that some of the, at least currently, that perpetrators of core international crimes will voluntarily travel to Ukraine as of date, and also this complexity, which is very which is a reality of pursuing the extradition cases amid an ongoing conflict and all the interconnected issues that goes with that. So in that context, UJ is in the context of Ukraine seen as a global positive complementarity tool which interacts with domestic efforts and goes beyond the traditional principle of complementarity. It's guided by an idea of coordinated imperative and a coordinated dialogue between multiple jurisdictions that have a common engagement and that align themselves to a common objective. Why is the situation in Ukraine so unique that it brings almost this idea of a sui generis type of positive complementarity approach? That's also because Ukraine has positioned itself as a proactive contributor to global justice. Well, first and foremost, of course, over the past decade, the Ukrainian justice system has demonstrated both its willingness but also its capacity to investigate and prosecute. Such a demonstration has extended to also the support to third states investigation through Eurojust, coordinated JIT, but I'll leave the representative of the Genocide Network and JIT to explain in more detail. I also want to commend the fact that very recently and even at home in Ukraine, Ukraine's recent legislation has been reviewed in October 2024, bringing also Ukraine in a position to investigate and prosecute crimes committed abroad by implementing also a universal jurisdiction article and mechanism in its domestic jurisdiction for most of the international crimes, war crimes, crimes against humanity, genocide, the crime of aggression, and the use of weapons of mass destruction. And I think the Ukrainian legislative has to be commended for that. And that's irrespective of the location of the crime. And finally, Ukraine has also signed the Ljubljana and Hague Convention, which in itself and within the instrument itself includes that principle of aut dedere aut judicare, which leaves no space to safe haven. It's either you prosecute or you investigate. A third option is not possible. So for all these reasons, those international justice tools are not exclusive from one another. They are complementary. And that creates this really interesting, but unfortunate, of course, we wish we weren't here to discuss that, but really interesting sui generis positive complementarity approach, which we are trying to push in the handbook and the different projects from GRC. Thank you.
Thank you so much, Jeanne. I will now give the floor to Alexander Zeus. Alexander is the head of the Unit for Interaction with Intergovernmental, Governmental and Non-Governmental Organizations Department for countering crimes committed in the context of the armed conflict within the Office of the Prosecutor General of Ukraine. Alexander, could you please describe how the OPG has worked together with international organizations and CSOs to fight impunity together and build this web of accountability Ambassador Costin was discussing before to really strengthen the investigation and prosecution of crimes committed in Ukraine? Thank you.
Thank you, Clara. Firstly, I would like to thank you for honor and privilege to attend this event, and special thanks to the team of the GRC who working together with the prosecutors and with other national international experts on this handbook. Mostly we want to build this kind of network of accountability both on national level with national Ukrainian civil civil society organization to build strong system of investigation such crimes within our trial investigation bodies like National Police and Security Service of Ukraine, and to establish strong connection between other international organizations like Commission of Inquiry, ICC, and other who could support our efforts and approaches for bringing perpetrators to justice. As for yesterday, national system has registered more than 166,000 war crimes, including the destruction of damage of more than 123,000 civilian infrastructure facilities, 437 strikes on 310 electricity facilities since 24 February 2022, and 364 cases of sexual violence in conflict, and 476 crimes against children. So mostly when you have such numbers of war crimes committed in Ukraine, you have not possibility to investigate it more effectively without helping of the international and national organization who could document such type of crimes. So if we will take results of investigation of national system, for 896 people have been charged in committing of the war crimes. 653 cases have been sent to court, and 178 people have been convicted for committing the war crimes in Ukraine under the Article 438, like war crimes. And if we will take account, let me pass it through. So the scale of figures helps to imagine the scope of actions that require to record these crimes and resources that needed. It's unlikely that any national investigation system will be able to cope with such a challenge, but very understanding of possibilities to intensify work in international crime in another jurisdiction, to provide legal support to witness and witnesses, and to launch criminal law mechanism in the country of residence is already worth a lot. So definitely, if we could have strong connections with other jurisdictions and to receive information that they have willingness and possibility to investigate such type of crimes, so we're definitely open to share all the relevant information and to fill the gaps that they could meet during the investigation, because mostly Ukrainian prosecutors and investigators have possibility to review crime scene, to collect like 80, maybe 90% of the evidence, but we are grateful for support, and every court decision, every notes of suspicion that we met in media, like the Finnish case, like case in Lithuania, cases related in US with US governments and with US victims of this crime. So definitely it's kind of inspiring for prosecutors and investigators when somebody shares the burden of the collecting evidence and bring the all perpetrators to the justice. So definitely we are grateful for such support. We are grateful for GRC who are working together with the prosecutors on central level, on regional levels, and they have such a project like Mobile Justice Team who works with prosecutors in Kherson and Mykolaiv. So definitely that's kind of a building of this network that we mentioned before. So thank you. And in continuation of these words about strategic plan 2023-2025, I think now we try to establish continuation of such a plan, because definitely it takes a lot of time if firstly strategic plan was aim of this strategic plan building a structure of the investigation, structure of the prosecutorial bodies, and we developed such system on central level. We created such units who are responsible for different types of crimes, like crime of aggression, crime of genocide, cooperation with joint investigation team, CRSV unit who responsible for gender-based violence. And the next plan will be concentrated, and focus of the next plan will be on the priorities of the system, because we need to choose priorities to move further with such a strong plan of the investigation.
Thank you so much, Alexander, for sharing this with us and really confirming the need for third states to step in the game and to really assist Ukrainian authorities, prosecutors, investigators in this fight. And this is why I'm now turning to our third panelist, Mr. Mateusz Perzis, is the head of the Genocide Prosecution Network at Eurojust and interim head of the Joint Investigative Team Network Secretariat. Could you please also present the international cooperation mechanisms that have been set up between Ukraine and EU member states since the beginning of the full-scale invasion to really foster this cooperation, coordination of efforts, and maybe tell us, in your perspective, where does universal jurisdiction fit within those mechanisms? Thank you.
Many thanks for inviting me to speak on this event. I would first take the opportunity to congratulate you for making this handbook, for producing it. It's absolutely welcome its applicability, but also the technicality of it. It really offers a guide, as you rightly pointed out at the beginning, to all practitioners, but also, I think, broader interested public, academia, civil society, into how technically universal jurisdiction is working, both on substantive, procedural component, and so on. And I see great applicability of it also beyond the Ukrainian scope. I think we should sort of acknowledge that as well. It might have been, of course, produced with that view, but it actually can give a very useful guide also for any other situation, and unfortunately, there's quite many of them around the globe. Now, it's a bit of difficult position to speak the last when such a great speakers before me, and many things have been said by Ambassador, of course, and also by my colleagues panelists here in terms of cooperation frameworks and where we are and what has been said. So I will try to sort of give some new perspectives instead of just repeating that. It's for example, just giving you a bit perspective from the Genocide Network, which through our flexibility we could actually respond in 2 weeks after the aggression. We already had a first meeting with all members, so it means EU, so 33 states, plus civil society organizations, plus prosecutor of the ICC, plus Prosecutor General of Ukraine, and many others. We had sort of a hybrid meeting basically immediately in 2 weeks after the invasion, where we could actually discuss the sort of issues of accountability. And here I would really need to congratulate Ukrainian authorities, because it's historically unprecedented what we're seeing now. That you have a country that's having 2 fights at the same time, and one is fight on the battlefield, and the other one is fight against impunity. And that's historically hasn't been done yet, because sometimes it can actually contradict itself, but it also stretches the resources. What happened in the past was always you had sort of an end of conflict, and then documenting, and then going into a process of justice. We're doing all at the same time, and that's really something that it should be recognized and acknowledged, because it puts quite a lot of burden on all involved stakeholders, but also actors. But as Ambassador has put it, the web of accountability and so on, that's what we kind of refer to as sort of an ecosystem where you have many various actors, very many partners in this that range from international community, various organizations, to, of course, national states, both territorial and universal, civil society organizations, and all need to sort of work together to deliver justice. And we've seen many successes already, and I think we'll see many more in the future. But just to kind of maybe give you a bit of to respond to your question on this cooperation framework. So we had, of course, the setting up of a joint investigation team in a month after the invasion, at that point with 3 countries, and then that was enlarged. And a bit of the idea what a joint investigation team is in that respect, it's sort of a mini treaty between countries where the countries agree among themselves how they will conduct an investigation. So we've seen this kind of cases being, or this kind of cooperation regime being used a lot in organized crime cases. For example, you have a criminal organization that does drug trafficking and works in several jurisdictions. So those authorities set up a joint investigation team and say, hey, we have sort of same criminal organization that we want to prosecute because it has various components in different countries. So the only way is that we actually set up this framework and exchange evidence, and it can also result in joint action days and so on and so forth. But using a joint investigation team in core international crime cases is much more complex. First applicability of this tool was in relation to Syria against regime crimes, and the first JIT of this sort was between France and Germany, and then later joined by Sweden, that resulted in a very well-known Koblenz trial, and then conviction of 2 high-level ranking Syrian military for crimes against humanity. Another use of joint investigation team as such we see is still very much ongoing is in relation to the crimes committed by Islamic State against Yazidis, where we have 4 countries who are part of that JIT, namely Sweden, Netherlands, Belgium, and France, and then also supported by still the UN mechanism UNITOD until last year, and the IIIM as well, and several other countries who have interest in that particular investigation and prosecution. And in that JIT, that was where the countries agreed their strategy, their objective, and that was to avoid re-traumatization, because it was quite clear that the pattern of functioning of Islamic State was in relation to Yazidis, but also other minorities, was to have multiple perpetrators against individual victim. So the approach was not kind of a suspect focus approach, but was actually victim-oriented approach in that JIT, where you try to build up cases from perspective of witness testimonies, and then from that identify individual suspects, work between countries to avoid that each country would go to the same victim on multiple occasions, asking sort of same questions, but just for a different perpetrator. So to sort of merge those questions and do it in one go. So there was quite a lot of experience at Eurojust in conducting joint investigation team, also in these complex cases, before 2022. And of course, then with the aggression against Ukraine and the war, the joint investigation team seems, of course, as a very much a tool that can support these efforts as well, which is led by, at the moment, 7 countries, with many also, of course, other countries supporting or contributing in one way or another. But from these sort of multiple, let's say, mother JIT, then of course you can have sort of various cases coming out that can be treated then on bilateral basis or in different settings of JITs and so on. So that's sort of a structure that can support long-term dedication and commitment, sort of a framework of cooperation in that respect. Another aspect was, of course, what was also mentioned was the setting up of core international crimes evidence database. And this, I need to say that it doesn't have geographical scope and it doesn't have temporal scope. And that's important to know because despite the fact being created with, as a sort of a response to the war in Ukraine, it has applicability for a much broader situation and context. And that's sort of a central depository of evidence. And here we need to distinguish from what other institutions work, also what our collegial agency Europol does, which works with information and leads, while CSAT actually works with evidence. So it means that on national level you need to have an open file, judicial file, where where a prosecutor would already sort of define what is relevant for his or her case or prosecutorial strategy, and that information, or basically those evidence, are then shared with CSAT. But now you need to understand, when you have from this evidence coming from various countries to a central database, you actually multiple those efforts because you can have much better understanding of certain situations. For example, a witness in 3-4 countries, so several witnesses in different countries might be speaking of a same incident or same event that those countries would not be aware of. So you have within this database sort of very good bird's eye perspective or umbrella view or whatever you want to call it on where you can actually have those links, but also where you see the gaps. So because you might have in individual countries opened war crime cases for victims of torture and so on, but when you put that together, you see that there is a pattern. So you might go, one step beyond that and say, why not looking into prosecuting these as crimes against humanity? Because you have quite a clear pattern. And that's that kind of interaction between the evidence coming in, the analysis done, and then sort of a legal analysis as well in offering sort of advice, contribution to prosecutors on the way forward. So that's on that one. And then maybe not to use too much time, I think I'm kind of getting toward there. Role of universal jurisdiction. So I think first we need to a bit manage expectation. Like what John was saying, universal jurisdiction is sort of a last resort. But on the other side, it does connect the various investigations that are there with all its pros and cons or limitations and challenges. Of course, limitations can be that there should be a nexus, the presence of a perpetrator, or certain more deep connection with the crime or specific incidents, and so on. But we've seen these cases being opened, and I think we really need to go here on a sort of a long-term strategy that when you have those multiple ongoing investigations and you're able to connect them, whenever there will be sort of a perpetrator here and there, or we've seen the case in Finland as a nice example, those countries will be able to immediately respond. So they will be able to actually not start from scratches, but there's a wealth of documentation within kind of third countries, who are connected to Ukraine as well as territorial countries, and that works sort of in symbiosis of exchanging information, evidence, to be very quickly able to file indictment or even to do the arrest, file indictment, and so on. In terms of the number of universal jurisdiction cases, I think it's the way the conflict goes. I mean, all wars end and then people travel for one way or another. I think also here we'll see people traveling sooner or later, and then these cases will be ready for prosecution and so on. I would maybe make here a comparison with Rwanda, where the genocide occurred 30 years back or 31 years back, and you had willingness on various levels. So first, a territorial country was willing to prosecute, and it has prosecuted cases. Then you had international community responding with the appropriate mechanism, setting up ICTR, so International Criminal Tribunal for Rwanda, to do those cases. And you had then also universal jurisdiction countries who apprehended fugitives, done the cases. But just like in terms of numbers, on ICTR level, you've done around 100 cases. On national level, we have around 50 to 100 closed cases with around 100 ongoing still investigations in many countries in relation to Rwanda cases. And of course on national level, a lot of both through the Gacaca courts, but also through prosecutions, many cases. And 30 years after, we still have more than 1,000 fugitives at large, despite all these efforts. So that gives you a bit of perspective that you need to really have, that this is a lifetime work. So I think when I will retire and you know, a young generation will still have cases and investigations to run in this respect. So that's first thing, like commitment, dedication, and this kind of handbook that we discussed today is another tool in this sort of structured support. And that's now my second point is the importance of this structured support through CSAT, through ICC, through setting up tribunal for the crime of aggression, and so on and so forth. That will give viable and meaningful response for future cases, and either on national level or international or through universal jurisdiction, and so on. And also in this respect, I need to mention Ljubljana Hague Convention as well, which is another sort of framework that will give this strong structural support to the future. I was privileged to be involved in all those negotiations over the past decade to get this instrument. So some absolutely strong believer. Was also the whole negotiations happened in my hometown in Ljubljana. But it's another sort of in a way glue or a web or sort of instrument that will be able to reach beyond only kind of Europe, but it has a global outreach. And of course, we never know in the future where the perpetrators will be found or where they will be located. And that's why it's important to have such a global framework, because in a long run, in 5-10 years, a person might be found, you know, a potential suspect might be found in completely non-European environment. And then it's always difficult to get sort of cooperation or even extradition with countries with which you don't work immediately or you don't have a legal framework. But this is a global framework that will allow that cooperation, so I see has great relevance, of course, for the Ukrainian context, but many others. I think I could go on for another time, but I think I'm a bit here already kind of testing the limitations, so I will actually stop and, of course, happy to answer any questions.
No, thank you so much, Mateusz. I think it was really good. You may have been difficult to speak last, but it was really great to have your insight at what already exists and what will exist in the future. And I really don't want to interrupt you, but I would love to keep some time for to get some questions from the audience. Just maybe a couple of reminders for those who attend either here in Acer or online. For those in Acer, if you have a question, we have microphones that we will be able to pass on. Just please make sure that you press on the button to turn it red to speak and green to speak and red when you're finished, and to speak slowly for interpreters. So not taking my example, but slower than me would be better. And I remind you for those who are here with us that the event is recorded. So you are not filmed, only the panelists are, but your voice may be recorded. So if you have a problem with that, you can also just write down your question on a piece of paper and pass it on. For those who attend online, there is a chat box in the live, so please feel free to ask questions there, and my colleague Placici will pass them on. So there is a question online. No question online for now. Yeah, please go ahead.
Yeah, thank you for giving me a floor, and for speakers for the extremely interesting and inspiring presentation. I represent Truth Hounds organization, and my question is, have you cooperated with some NGOs in Ukraine that document war crimes, and at least 2 investigations abroad of Ukraine in France and Switzerland open based on our submission, and at least I think 8 submission were we sent before. And so maybe it will be useful to include these cases in future mapping about what you say before, and it can be help to be, I don't know, fuller, and maybe give a whole picture of this very important UJ instruments in the accountability system for international crimes. Thank you.
I can just answer quickly. Yeah, we have been talking with your colleagues and in the 2 missions in Kyiv. And we tried really to include all the cases that are publicly known, because of course there are some cases, and also as lawyers we know that with confidentiality and secrecy of the investigation. But indeed, yes, please, and also if you see any information that are missing, some of the country studies we've been, I think, at least Clara can testify to that, some of these countries had never really been analyzed from the point of view of universal jurisdiction. So if you do see errors, or if you want to add anything, please send it our way. And of course, with regards to cases as well, definitely.
Yeah, thank you, Mike. I just want to say that it's a really huge and great job. We understand that, and I checked it, and I see that it doesn't include, and it will be very good. Yeah, thanks.
Here we go. Thank you. I'm interested in learning more about how universal jurisdiction is used as a last resort, and how those decisions are made for individual cases. So when a prosecutor decides that they want to take a case, is that decided, which country that's done in, is that decided based on that individual prosecutor looking to do that? Is it a diplomatic decision made between embassies or ministries of foreign affairs? Or is it something else entirely, maybe more based on where the victim is?
I think it depends of both diplomatic way and prosecutorial decisions. When colleagues, prosecutors met their colleagues from other countries, they try to establish such kind of system, how to bring perpetrators to justice. And mostly, I think, even from my perspective, when we have decision of other jurisdiction, it could be much more effective for prosecution. When in Ukraine we have a lot of with court decisions, but not. I think they're not so famous as Finnish one or like Lithuanian suspicions or like even U.S. Notice of suspicion.
If I can add, yes. So how it worked actually in our case. First of all, as I mentioned, so and thank you for mentioning this. So it was not a last resort issue. It was one of the elements of our web. And we were inspiring the other countries to go ahead. For instance, in the US case, it was about US civilian, who was severely tortured in the region of Kherson, in like first months of the occupation, and the perpetrators, alleged perpetrators, they definitely know that this was a US civilian citizen and they intentionally did this. And of course the US has no universal jurisdiction, and actually they have changed their legislation in December of 2022 in order to have jurisdiction over even such type of case. And this was, I think, very important because once again it was a matter of cooperation between our Office of Prosecutor and our investigative authorities and the US colleagues. In cases which were under JIT and which where charges were brought by the Office of Prosecutor General of Lithuania, both of the victims were Lithuanian citizens. One of them killed in Mariupol and the other was severely tortured in Melitopol. And both of these cases were the result, and actually it's quite unique. It's quite unique because in both cases, charges were brought without physical access to the crime scene, which is also quite unique from the point of view of like how modern investigation and prosecution can be handled. Finnish case, first verdict actually of the third jurisdiction in course of the international crimes committed in course of this war of aggression. It actually was quite a big story. Once, I think it's no secret at that moment. So we have applied for extradition of this person for crimes committed before full-scale invasion. And the person was arrested by the authorities of Finland, and then he was released by the court in Finland, which really, of course, it was great disappointment to us, but it was actually quite big outcry, public outcry, in Finland and in Ukraine. And then I will skip some elements of our communication, but it was professional communication between our authorities, which ended, so we discussed several options how to go ahead, but it ended with the idea or the decision of our colleagues in Finland to start case there. And then it was the other way around, actually. So we helped our colleagues from Finland. There were several visits of them to Ukraine, and it was quite intensive work of both investigators and prosecutors from both sides. And actually it led to a verdict of court in Finland with a conviction to, I think it was life imprisonment, yes? Yeah, right. And actually one of the latest cases, I don't know if also as a result of efforts of JIT, was that the case, most of the case was investigated in Poland and then sent to Ukraine, because Ukraine has an ability to try alleged perpetrators in absentia. And this was the element we have and we can use. So you see how it works in different situations. So there is an element, of course, of victim. There is an element of dialogue between two law enforcement or two prosecutorial authorities. There is an element of joint investigation team under Eurojust and access to CSAT database as a source of exchange of evidence. So this is how it works. And actually, I think that in this situation, it shows how international cooperation can yield results, first of all, not only to justice as it is, but first of all to victims and survivors, because they see that the person who committed crimes against them or the relatives of those who was killed, they see that the justice is in action. I'm awfully sorry. I need to leave. Yes, I'm sorry to say it. I was happy to contribute to the discussion, and thank you for everyone. But unfortunately, I need to leave immediately. Thank you so much.
Thank you so much. Thank you for being here with us. So I believe we have one more question in the room and then one online, right?
We have a couple online, but
So let's
I
take
don't know what we
one.
have time for.
And two in the room. All right. So let's take maybe these 4 questions. If you could just like keep them quite short, and then we'll have to.
Thank you very much for this, and it's a very exciting prospect, the sort of potential of universal jurisdiction. I was wondering about coordination between different states that exercise universal jurisdiction. How do you ensure that a perpetrator who ends up in Germany, maybe Argentina, could build a stronger case, for example? I was wondering if there's any sort of coordination, if that would be through the Office of the Prosecutor General or of Ukraine, or how that would work. Thank you.
Thank you for question. I think mostly we have such tools like Eurojust and coordinational meetings in Eurojust, and when we could share our opinion straight with counterparts and to see if they have some concerns, if they have some kind of gaps, and to fulfill them from both sides. So definitely, I think it will depend on the prosecutors and their willingness to take responsibility for result of the case.
Thank you. Maybe let's take your question in the room, and then we'll have 2 questions online.
Thank you. My name is Olesya. I'm from Ukraine Legal Network, Nuhanovich Foundation, and we are a representative from civil society. And I will be asking you a practical question more about how, in this perfect tool, I didn't read it yet, sorry, but how victim interests are and victim needs are taken into account. I will start with real examples. So, as Mr. Our ambassador Kostin left, to my big regret, because I wanted to hear him as well, it was noticed that a lot of victims and witnesses are relocated, and they are living abroad, including here in the Netherlands. Due to restricted international universal jurisdiction here to trigger any investigation, it's for now currently it's almost not possible. But they are here, and questions are coming from the fields. So due to complex situation that is happening, for example, national investigations, verdicts which are there already, their enforcement outside, 178,000 convicted criminals, how to find them, how to extradite them, how to deal with enforcement of these victims. It's a huge challenge. So the victims that we are facing, they are usually saying, okay, we had a criminal investigation in Ukraine, we have victims, but we don't have any satisfaction because the person is still, for example, free, and our relatives who have been tortured and killed, we cannot really find for us, it's not really redress, it's, there is a justice, there is accountability, but there is no satisfaction. So in this complex situation that I just named, how do you see because coordination platform in Eurojust and between prosecutions, it's great platform which victims are not really aware, involved, or they even don't know how to access to it. They are coming to social societies, organization, and asking, can you help us? To which window we can knock with our problems, statements, with our questions about how to trigger or maybe be a part of this core investigative crime database with finding in national investigations. What you would suggest, how we can help them, how we can be this bridge, what role we can exercise now and here when we receive all these questions. Thank you. It was a little bit too large question. Thank you.
I think advocacy of non-society of society organization, it's a very important question. It's tough questions about satisfaction of the victims and witnesses, but at least we have such instrument like in absentia procedure that victims and survivors can be heard in the courts in the law enforcement pre-trial, and we could receive such type of decisions even with in absentia procedure. Then we try to establish some changes with Interpol in their red notices to implement such type of decisions, to find all the perpetrators, to bring them to real justice or to implementation of such decisions. Then Office of the General Prosecutor's Office established such type of platforms like Coordination Center for Victims and Witnesses. And they could be a platform of connection between victims and survivors even even abroad with straight investigators and prosecutors in their real cases, just to be connection on this platform. But if we will take about real imprisonment, it's a lot of work still needs to do for real convictions, for real bringing perpetrators to justice.
Thank you. Thank you. So I offer to take two very quick questions from the people who are attending online, and then we'll move to closing remarks.
I think they can be dealt with quickly because they build on a lot of the discussion that's been had just now. The first question is, are there concerns about different trial standards in different jurisdictions and how that can pose subsequent challenges? The example given here is the ability to conduct trials in absentia in Ukraine.
I don't think that we have such concerns. Of course, if we will have possibility to share our evidence with other jurisdictions, we will support such type of questions. We will share all the evidence that we have, all the needed information. We are ready to fulfill the request about mutual legal assistance with such countries. So we are now in the process of changing our legislation regarding the in absentia procedure. So definitely we will to make higher standards of the our in absentia procedure. So I think we definitely try to change with all the concerns from international experts and even national experts regarding to our procedure in absentia.
And I think the last question is, I'm going to summarize it because it's quite long, but how can civil society, particularly civil society that has been working on the ground and collecting information and various kinds of evidence and data, how can they contribute to or comply with the CICED standards and compatibility in that sense?
I think I'll take that one and then also try to respond to your question. First, civil society contributions. I need to here highlight a project we started recently, last October, which is externally funded from Commission, and it's actually trying to revitalize the work from September or basically 2022. At that point, on the request of actually Ukrainian civil society organization on the ground, we joined forces with the Office of the Prosecutor of the ICC to develop guidelines for civil society organization on documenting international crimes. And similar to this, the handbook has much broader, of course, applicability, but was a direct result of that request from those meetings that we had within the Genocide Network with civil society organization. We had actually, I think, even representative of Truth Hounds and a few others who were saying, we're on the ground, could you give us sort of methodology, standards that we need to comply with, because we don't know where our information will go later on. Huh? So that's one thing that has been produced, has been done, it's there. And now through the project we have at Eurojust, we actually want to as I said, revitalize that and have sort of broader discussion, technical briefing, consultation on the applicability, on basically how that works with various, not only Ukrainian, but various civil society organizations. We just had last week a technical briefings in relation to Asia, civil society organization using it in their context, and so on. So that's one thing that I would say, be very careful in what you do, so kind of do and don'ts, because despite the best efforts you might have at the moment, a civil society organization, you might actually compromise the evidence for future cases. Or, you know, there might be 5, 6 different NGOs going to the same victim, and so on. So that's something that you need to take into account in your planning, and take these precautionary measures into what you will do first. Do you have appropriate knowledge, appropriate tools, appropriate understanding to deal, especially like with vulnerable, traumatized victims and so on. So that's what I would suggest there. But then, also just to respond to your question earlier on victims' perspective, that's a very good question and complex one, because what actually is justice to victim? I think each victim can understand that differently. One would just say, okay, some compensation, I'm fine, you know, or rebuild my house and I'll be happy to live there. Further on, some other would say, no, I want to see the suspect or the perpetrator being tried and so on. So that's another thing. But from civil society perspective, I think, and here not speaking within kind of Ukrainian context, but broader, it's really to manage expectation. Because even those victims and witnesses that have given their testimony and you know, contributed to that, nothing might happen for the next 5, 10 years. It might take much longer. So that's really important to be very frank at the outset. Their contribution is super valuable and important, but doesn't mean that it will lead to a result immediately. So it's a lot of patience, a lot of understanding, a lot of managing expectation, but also being very honest in that. Secondly, also in terms of victims, and of course their contribution, you also have different types of victims. If you're a victim because your house was destroyed by a bomb, okay, of course you have no place to live, and then the Russian forces have sort of taken the territory, you're in the middle of the fighting, you need to leave. You are a victim of war crimes and all of the aggression. But in terms of like what can you contribute meaningful to accountability, I would say quite limited to that, because you would just be able to say, yes, my house was destroyed. Yeah, the bomb fell on and was destroyed. So it's also different, kind of levels on who victims, their possible contribution. It would be different if someone would have sort of, linkage element or seeing a perpetrators and so on. So in that way, you need to treat it in each individual differently and understand what they can contribute. And is that contribution to sort of like proper accountability, criminal process, or it's more to kind of reparations or civil aspects, and so on and so forth. So in that way, I think there is no standardized answer, but really looking at each individual through their own, of course, perspective and trying to see what would be most meaningful that, but at the same time being very honest in what what kind of expectations there can be.
Thank you so much. We could, I'm sure, continue this conversation for a lot longer, but we have to stop here. So thank you again to all our panelists. I think we can give all of them a warm round of applause before we close. Thank you. And lastly, to give some closing remarks, I'm very happy to welcome Dr. Nout van Wondenberg from the Ministry of Foreign Affairs of the Netherlands, which I again join my colleagues in thanking for the support in the project. You have the floor.
Thank you so much. Distinguished panelists, dear guests and participants of this event. As a legal counsel, the premises of the Esser Institute are very well known to me, and I'm very happy to be able to say a few words on behalf of the Ministry of Foreign Affairs of the Kingdom of the Netherlands. As you all will be aware of, the Netherlands considers itself as the caretaker, or at least one of the caretakers, of international law. Nowadays we call The Hague the city of peace and justice. But when I was still working at the International Law Division of the Ministry of Foreign Affairs, we called it the legal capital of the world. Coming to the topic of universality. Together with South Korea, we, the Netherlands, are the advocates of universality of the Rome Statute of the International Criminal Court, an institute that forms one of the cornerstones of international legal order, and unfortunately currently targeted by some unprecedented sanctions. Moreover, the Netherlands is lead nation of point 7 of the Ukrainian President Zelensky 10 points peace formula. Point 7 is restoring justice for Ukraine. And that fits perfectly under the obligation we have in our Article 90 of our Constitution, which gives us a task in developing the international legal order. We applaud Ukrainians' endeavors to seeking accountability for international crimes committed in Ukraine while the full-scale invasion is still continuing. With already 166,000 war crimes registered, as we heard from Ambassador Kostin, as well as from Mr. Zius of the Office of the Prosecutor General. This is a huge challenge, and the Kingdom of the Netherlands is a proud key partner, as Ambassador Kostin mentioned it, in regard of these endeavors. The handbook presented today will undoubtedly serve as a valuable tool for enhancing knowledge and strengthening practice. Referring to best practices, as the handbook, among other things, is doing, is always very helpful, as long as it's not considered a blueprint, because every country is unique in its own kind. The International Crimes Act, adopted in 2003 in the Netherlands, implements universal jurisdiction for core international crimes, such as war crimes, crimes against humanity and genocide. And the definition of some of these crimes has taken verbatim from the ICC statute, a statute that was able to welcome Ukraine as its latest and 125th member of the family. Moreover, as Ms. Sulzer of Global Rights Compliance rightly mentioned, Ukraine signed, as one of the currently 40 signatories, the Ljubljana Hague Convention, an instrument aimed at strengthening international cooperation in investing and prosecuting core international crimes. With international cooperation and support, by learning from each other, and by bringing national legislation in line with international standards, as well as promoting and enhancing universality of these international norms and standards, we are able to obtain results larger than the sum of its parts. Thank you.
Thank you so much, Doctor. And so with that, I think we'll call it an end. Thank you again so much for being here, for attending either in person here in Acer or online. Thank you again for all of our partners on the project, the Dutch Ministry of Foreign Affairs, IDLO, Acer Institute again, the Center for International Legal Cooperation, and the Netherlands Helsinki Committee. Thank you to the Embassy of Ukraine in the Netherlands, to the OPG, to Alexander for being here today, to the Genocide Network, and you, Matthew, for being here today. Again, as Jan mentioned, if you spot any typos, I think some have already been spotted in the chat. If you see any cases that have been made public, but we have not included in the handbook, please do send them our way. Please trust me when I say that we have read it hundreds of times, but we could read it hundreds more and still find things and room for improvement. So it is meant to be a work in progress. There will be also the case mapping that will be launched soon and that we aim to update. So please, anything you spot, send them to us. Thank you again to Acer and more specifically to Floris, Maria and Kim for helping us organize this event. And for those who are here in person with us, we have a small drink and reception just following the event. And I'm sure you can still keep harassing our panelists with more questions. And I will stop now. Thank you so much.